there has been steady criminalization of Indian politics. To deal with this issue, the Supreme Court issued a significant order today. In this edition of HT Conversations, I have with me Ashok Bagriya, the legal affairs editor of Hindustan Times, to tell us about the context in which Supreme Court issued its observations and the significance of this order. Ashok sir, what was it that the Supreme Court was considering in terms of the question, and what did it say?
Basically, Prashant, there were a bunch of petitions which were filed in the Supreme Court sometime in 2013, and they had raised a question or posed a question to the Supreme Court saying that a member of parliament or a member of a legislative assembly should be disqualified if there is a criminal case against him. But what they said was that if the court has already framed a charge sheet, the disqualification should kick in the moment charges are framed by the court. Now the rule at the moment is, or the Representation of People's Act says, that a lawmaker cannot be disqualified from contesting election until and unless he or she has been convicted by the court of law. So today this particular bunch of petitions was actually there was extensive hearing in the Supreme Court on the issue, and today a verdict was delivered where the Supreme Court categorically said that we are not going to get into the area of lawmaking, but they expressed concern about the rising criminalization of politics, and they have said that basically with deep sense of anguish we recognize this serious issue which is afflicting the Indian politics, and they have issued a slew of directions which basically say that if a candidate who is contesting election on a party ticket will basically disclose to the party if he has any criminal antecedents, the particular party will put the criminal antecedents of its candidate in bold letters on their websites. And also one more additional thing that the court has said is that this particular criminal antecedents of a candidate should be given wide publicity, not just in newspaper but also in electronic media.
Do you think the court has then respected the spirit of separation of powers? It has respected the principle of innocence before guilt is declared, or do you think it could have been stronger in terms of binding instructions that that it could have issued to deal with this serious
Well,
problem?
in fact, all these issues have been dealt by the Supreme Court in its verdict. Now, coming to the first question of separation of powers, the Supreme Court has categorically dealt with it. In fact, one of the arguments given by the Attorney General who was appearing for the central government said that the court should not get into the issue of lawmaking. All they need to do is executing and implementing the law is the task. So the court in its order has said that we are not going to cross that Lakshman Rekha which has been drawn by the constitution, and we are going to respect that Lakshman Rekha, and we request the parliament to enact some strong law to deal with rising criminalization in politics, number one. Number two, as far as the issue of whether the Supreme Court could have come out with a stronger guidelines or not. Now that is a very debatable issue. What the Supreme Court has done today is it has done its best. They have said that we recognize that this is a problem which is on the rise, and we want to do really something about it, because if there are more and more criminals entering politics, it strikes at the root of the democracy, and people of this country have the right to be governed by good people. Hence, they are saying that in our the limited powers that we enjoy at the moment, we believe that we can only give directions, and as a part of that thing, they have said that we are going to give this set of directions, and that is how the matter is going to proceed from here.